Hello and welcome back to the Hebbets and McCallin video blog. Today we're going to be talking about driving under the influence of marijuana cases. This is definitely a hot topic in Colorado these days. First of all, can you get a DUI if you're under the influence of marijuana? Well, the short answer is yes, you can, although a lot of the traditional notions that you think of with regard to an alcohol-related DUI are very different from that of a marijuana DUI. We're going to talk about some of those things. First of all, how can an officer tell whether or not a person's been using marijuana? Well, there's the obvious example. If they pull somebody over and they approach the car and they smell the odor of marijuana, which is a very pungent smell, on either the driver or somewhere in the car. Then they ask the driver if they've been using marijuana. The driver admits that they have. What has the driver done? They've just given the cop probable cause to arrest them. But there are also some more subtle things that the police are looking for. For example, they're going to be looking at whether or not the driver has bloodshot, watery eyes, slow, slurred speech, whether they're thick-tongued, maybe balance issues getting out of the car, things like that. They're also going to probably have the person go through field sobriety testing. Now, we're talking about things like standing on one leg or walking a straight line. Interesting thing about those standard field sobriety tests is they were created in the 1970s specifically to target alcohol impairment, not any other type of drug. And attorneys like us are challenging the admissibility of those field sobriety tests being admissible in court in marijuana cases. But right now, most Colorado courts are allowing that evidence to come in. So assuming at that point that the officer has probable cause to arrest the person, they're going to require them to take either a blood or a urine test to confirm the presence of marijuana in the system. Now, another issue with regard to the testing here is that marijuana is a drug that can stay in the body for many days, up to 30 days. This is very different from, say, alcohol consumption, which can leave your body in a matter of hours. So, how can the courts determine how recently a person smoked? Well, to make things more difficult, there is no per se limit of impairment in Colorado. Meaning, for alcohol cases, you can't have a blood alcohol level of 0.08 or you are presumed to be under the influence. There is no such standard for marijuana cases. So juries are tasked with having to just look at this evidence and decide whether or not a person is under the influence. The bottom line is that this is a very complicated, newly developing area of law. And if you or a friend or someone you know is sided with one of these offenses, have them give us a call at Hebbets and McCallin. You really need someone who understands these issues to defend you properly. Thanks for checking out our blog. Have a great day.